here. This is finding from a judge.
Yeah, Judge.
Recording in progress.
Being recorded.
Inauguration land law and real property mooting competition.
I don't think I signed up for that.
Demand Foot versus Kaden. Yeah, Judge.
Recording in progress.
Being recorded.
Inauguration land
Good morning,
law
everyone.
and real
Welcome to
property
the
mooting
inaugural
competition.
competition.
I don't think I
On
signed up for that.
Tuesday,
Demand
we
Foot.
have
Possessory title against a family member who is a known beneficiary of the estate of John Han, the deceased. My duty today, Your Honor, is to address the first issue, and my junior counsel will address her submissions on the second issue. Possessory title, Your Honor, against a family member on the issue of the Honorable Trial Judge granting the declaration of title to Kaden, deceased. Section 3 of the Land Title Your Honor, is to address the Prescription Limitation Act, and my chapter 60(02) states, and I quote, title to land, including land and government, state land and government land, or any undivided or other interest therein, may be acquired by sole and undisturbed possession, user or enjoyment of for 30 years. If such possession, user or enjoyment is established to the satisfaction of the court and was not taken or enjoyed by fraud or some consent or agreement expressly made or given for that purpose, provided that, except in the case of state land or government land, such title may be acquired by sole and undisturbed possession, user or enjoyment for not less than 12 years. If the court is satisfied that the right of every other person to recovered land or interest has expired or has been barred, and that title of every such person thereto has been extinguished. This honorable court, Your Honor, has established a precedent in addressing issues of that nature. Permit me, Your Honors, to mention the case of the declaration of petition of Orin Haralal, number 74P of 2011, a land court case heard and determined by the Honorable Land Court Judge, Ms. Chandra Hanif, to whom it's a great pleasure to stand before today. This case was heard and determined by the Honorable Judge, and for the sake of brevity, Your Honor, the summary of this case is as follows. The petitioner had filed a claim for declaration for title to the plot of land in Campbellville, previously owned by his father. He built it on the backland of that property. While doing so, he was never objected to by the father. When the father died, he applied for a prescriptive title to the land. The Honorable Justice Priscilla Chandra Hanif, after hearing the petition and the opposing evidence and pleadings respectively, finds that the petitioner had established his claim for sole, continuous, and undisturbed possession without consent or permission for the period of 12 years. Consequently, the learned Justice Hanif found in favor of the petitioner and granted declaration of title to him. In this case before us, Your Honor,
You hear me? Okay. Now, in the Harilal judgment that you referred to just now, it dealt with a similar fact situation with family members. What made the difference in the Harilal judgment? You've given a summary, but you haven't highlighted for me what was the defining feature of the Harilal judgment that entitled the petitioner to the declaration.
Your Honor, the possession of that land was undisturbed. It was never challenged.
No, that's not the judgment. That's not the judgment. Does one of your juniors want to assist you? You have the judgment. Refer to me to paragraph 120.
The main issue, therefore, to be determined by the court is whether the petitioner commenced occupation in 1993 with permission and therefore not adverse. And further, if the petitioner was in fact a licensee at the beginning of his occupation, when, if at all, was the license terminated?
Right. So what's the exception to the family rule?
If he was the licensee, I am not sure.
Read paragraph 124 for me. It will summarize why he was able to succeed.
Okay. Your Honor, however, in 1996, when the petitioner commenced occupation of the house, the evidence of his brothers and sisters show that this was not the normal family relationship, which generally invokes the presumption of a license and permission, since the court accepts the evidence that the petitioner was chased out of the house by his father and went to live in the house on the disputed property against his father's wishes. Mr. Vindar Sr., in his own evidence, confirms that since the petitioner commenced occupation of the property, which the court finds to form the year 1996, he has been prevented from going on that part of the land, and the petitioner has asserted all rights of ownership to the disputed property. As such, the license, which initially existed in 1993, when the petitioner commenced construction, came to an end at the time as the petitioner became a trespasser. And the father was aware since 1996 that the petitioner was asserting his rights of the ownership of the disputed land. And as such, time would have started to run against Mr. Hilton's Vindar at that time.
Right, so in Caden's case here, did Caden enter with permission?
Respectfully, Your Honor, yes.
And when, if at all, did that permission come to an end?
When Mr. Foote purchased the land.
All right, continue.
Thank you, Your Honor. In the case before us, Your Honor, in its pleadings, the respondent admitted that in January 2009, at the funeral of Mr. and Mrs. Han, Debbie, the aunt, told Caden that he can continue to live there. There, Your Honor, it is evident that Caden's occupation of the property was by Debbie's consent, permission, and agreement. It is prudent to note that though Caden's agreement, he recognized Debbie as the superior title holder in the property by virtue of her interest and share in the parents' estate. Your Honor, given the judgment, in the case before us, Your Honor, in his pleadings, the respondent admitted that in January 2009, at the funeral of Mr. and Mrs. Han, Debbie, the aunt, told Caden that he can continue to live there. There, Your Honors, it is evident that Caden's occupation of the property was by Debbie's consent, permission, and his agreement. It is prudent to note that through Caden's agreement, he has recognized Debbie as the superior title holder in the property by virtue of her interest and share in the parents' estate. Your Honors, given the judgment, the trial judge failed to apply the relevant legal principles to the facts of the case as outlined, resulting in the rescission of Transport 456 of 2021. Additionally, the petition for a declaration of title by Chetram Prasad Lekram, number 1189P of 2014, another case heard and determined by Your Honorable Justice Chandra Hanif. Mr. Lekram brought an action to seek declaration of title to the plot of property in the Maiponi River, in which he claimed possession for 20 years. He reared cattle on the property and lived next door. Justice Hanif, in her ruling, found that the petitioner's claim of mere grazing of cattle on the property failed to cross the legal threshold required to maintain such claim. The petition for a declaration of title was dismissed. It is clear, Your Honors, that the court is strict in its application to Section 3 of the Land Title Registration Prescription and Limitation Act, and that any claim of adverse possession must cross that threshold to maintain a claim of adverse possession. Your Honors, in light of the foregoing, the trial judge, Justice Fear, failed to take into consideration the principles enunciated, as therefore made a grave error in his ruling. Therefore, counsels for the appellant submit that the declaration of the title granted to Caden must be set aside and the ruling for Justice Fear should be overturned. Here ends my submission.
Thank you. Do you have any questions to ask?
May it please this honorable court. I am Nikisha Daniels, Junior Counsel representing the appellants. The second issue at hand is whether a beneficiary in possession can maintain possession adverse to his or her co-beneficiaries. And what is the threshold for a potential beneficiary to seek adverse possession against another family member or a beneficiary in the estate of a deceased? Your Honors, allow me to turn your attention to the Guyanese Court of Appeal case, Matan versus Kujal. It was re-emphasized, Your Honors, and I quote, "The possession of a potential beneficiary of the estate of a deceased could never be adverse to a beneficiary in possession, and that family member could not maintain possession adverse to his or her co-beneficiaries." Your Honors, the primary issue in this case is not whether Caden can seek a declaration of title by adverse possession, but rather Caden's ability to establish that he has a sufficient degree of physical control and custody, and whether he can rely on Section 10 of the Title to Land Prescription and Limitation Act to crystallize his purported interest in the estate of a family member and a co-beneficiary. Section 10 of the Act states, and I quote, and whether no right of action to recover land shall be deemed to accrue unless the land is in possession of some person in whose favor the period of limitation can run, hereafter in this section referred to as adverse possession, etc. End of quote. This was also reiterated in paragraph 10 of the Mooting case, and I quote, in other words, it would be a thoroughly wasted exercise for any petitioner to attempt to satisfy the court that he or she has been in uninterrupted possession of land for the requisite period of years, together with the necessary intent, unless firstly, he can establish that he or she is a person in whose favor time can run. So, Your Honors, to establish whether Caden is excluded under Section 10 of the Act, we must look at his ascertainment of status on the disputed land. Based on Section 5(1) of the Civil Law Act, and I quote, if there are descendants, 1/3 of the surplusage shall be allotted to the widow or widower, and all the residue by equal portions to the children of the intestate, their descendants taken per stripes, in case or in any case, or all those children, etc. End of quote. The facts tell us that Caden may be a beneficiary in the estate of John, depending on the type of ownership set out in the transport. And it is his duty to establish that claim in an application to the High Court of Judicature, on which we will vicariously defend our client. What I must reiterate, Your Honors, is that Caden cannot claim possessory title to the whole of the estate, because being a potential beneficiary, he could not have possession adverse to that of Debbie. As well, there was never an intention to create legal relations. In the case of Romani versus Romani, and I quote, recent authority makes it clear that in family situations where one member helps another in a period of difficulty over accommodation, there's usually no intention to create legal relations. So there can be no tenancy, but merely a licensee. This is paragraph 13 of the Mooting case. Hence, Caden became a licensee in the estate of John Han, and that license was renewed admittedly by Caden in his pleadings acknowledging and acquiescing to the words of Debbie on several occasions and his failure to commit acts openly and adverse to my client's interests in and to the property. On every occasion Debbie traveled to Guyana, she stayed in the home of her father's estate without permission, objection, or open hostility by Caden. Even at the funeral, when she gave him the permission, there was an opportunity for Caden to openly object to Debbie's statement. In any case, Your Honors, it must be the fear of a plaintiff for possession against him that caused Caden to acknowledge Debbie as the superior title owner and continued his possession as a humble licensee. Furthermore, there are also no facts to prove that Caden wanted to seek a declaration of title prior to the property being sold to Mr. Damon. Caden may conjure the thought of claiming for the works he carried out in repairing and maintaining the property with his own money. But Your Honors, to whose benefit was this? It was obviously to Caden's benefit. He was living on the said premises rent-free, and there was a duty to maintain the property. Finally, Your Honors, I end with paragraph 25 of the Mooting versus Pujol case, and I quote, "The Honorable Justice Chandra Hanif in her judgment, the petitioner's application for prescriptive title to the disputed land on these facts could not have involved a more outrageous exercise. It was indeed a hopeless proposition, and it was exposed to absurdity at every turn and every stage of the three distinct portions of history under review. The learned commissioner of title fell into serious error as well by not applying the relevant legal principles to the facts of the case. The issues before him were totally misconstrued, and in many respects, his declaration of title in favor of the petitioner can be mindless or preserved." End of quote. Your Honor, we therefore submit that we reiterate the principles in the Mooting case, and that Caden, as a potential co-beneficiary, is in possession, could never be adverse to Debbie's interests in her father's estate. Here ends my submission, Your Honors.
Thank you. Let's see.
Do you think that remedy would be? I know this is not part of the brief.
Pardon me, Your Honor, I didn't get your question.
What do you think then that Caden's remedy would be if you say that he may be a beneficiary himself? And as a co-owner, he cannot be in adverse possession. Therefore, he should not come to the court asking for a declaration of title to the property. He has another remedy. Do you care to say what that might be?
Okay. So thank you for your question, Your Honor. In my humblest opinion, I feel that Caden should seek an action for damages against the total amount of money that was received by Debbie for the property that she sold to Damon. That would be the rightful action.
Thank you very much.
You're welcome.
Counsel for the respondent, ready to proceed?
Honorable judges, counsel for the appellant, my fellow counsel for the respondent, pleasant good morning. I, Ashmina Jagu, stand before this court as senior counsel for the respondent, Caden Han. With me is junior counsel, Evita Rodriguez, and researcher, Yashoba Parks. Now, if I may please the court. In this case, the trial judge in the High Court was fair and judged in his decision. I humbly praise this court to maintain the decision that the trial judge made on two alternative grounds. First, Caden's occupation of the property was adverse. And second, Caden has sole and undisturbed possession of the property. My junior counsel will address the issue of undisturbed possession of the property. Honorable judges, I hereby submit that any facts being omitted is not by intention, but by ignorance, and is not being done to mislead this court. I hereby submit that the property at 64 Brick Dam was family property owned by John Han, and that Caden Han was raised by his maternal grandparents after the death of his mother, Olga Han. Further, the respondent continued to live on the property even after the death of his grandparents in January of 2009, while his aunt, Deborah Dashhand, resided in Suriname, migrated to Suriname, that is, in 1989. Therefore, the respondent's occupation of the property was adverse. I further submit that the respondent had physical custody and control of the claimed property, and that the acts of the respondent in occupying, repairing, and maintaining the property were enough to establish animus, and that the respondent lived on the property
lived on the property even before he was granted permission by his aunt. Therefore, time ran in favor of the respondent from the date of John and Kamala's death in January of 2009. Further, I submit that the acquired title by the paper owner of the property has been extinguished by way of prescriptive rights. According to Section 3, the Title of Land Act, Chapter 6002, the first element the possessor must satisfy the court with is that he has physical custody and control of the claimed land. This is factual possession within 12 months limitation period. A similar issue was addressed in the case Tulsi Prasad Limited versus Andrew James, cited in Dennis Lee versus Lucy Walker, referenced on pages 28 and 104 of the bundle. In this case, the concept of possession was explained and the court agreed with Lord Brown Wilkinson. Wilkinson stated that avoiding reference to adverse possession would create less confusion and complication. I quote, "The question is simply whether the defendant squatter has disposed of the paper owner by going into ordinary possession of the land for the requisite period without the consent of the owner. Except in the case of joint possessors, possession is single and exclusive paper property. Therefore, if a squatter is in possession, the paper owner cannot be. A claimant to land by adverse possession needs to show that for the requisite period, he has factual possession, meaning a sufficient degree of physical custody and control of the claimant's land in light of the land's circumstances, and an intention to exercise such custody and control on his own behalf or for his own benefit. In this case, Caden was residing with his grandparents since he was 11 years old, while his aunt was residing in Suriname since 1989. Caden continued to live on the property even after the death of his grandparents in January of 2009. Honorable judges, the respondent had a sufficient degree of physical custody and control of the claimed land for 12 years. And if we calculate from the time his grandparents died to the time the claim was filed, he was within the required statutory time stipulated in Section 3 of the Title of Land Act, Chapter 6002. Therefore, my honorable judges, it is conclusive to say that Caden had factual possession of the property before it was sold to Damien Foote, and even before his aunt, Debbie, had transferred the land to herself. Also, we know that Debbie, Caden's aunt, was residing out of the country for 20 years and had not taken an interest to the property until after the death of her parents. Additionally, Your Honors, following the ruling in Tulsi Prasad versus Andrew James, reference on pages 28 and 104 of the bundle, another requirement for factual possession is an intention to possess. As stated in the case, and I reiterate, an intention to exercise such custody and control on his own behalf for his own benefit is an intention to possess. This ruling was also cited in cases Lacram versus Ramand, Shakila Kanai versus Basanti Prasad, reference on pages 48 and 88 of the bundle of authorities. It was established that animus must be examined on the basis of his conduct. Things he did that may act as evidence to show that he was using land in the way one would expect him to use it if he were a true owner. In applying these same principles, it is reasonable to say that Caden's intention may be proven by his conduct. According to the fact, Caden continued to live on the property even after the death of his grandparents. He continued to pay bills, maintain the property, and even paid taxes with his own money. Your Honor, it is not wise to believe that one will take care of a property in this manner, knowing that he or she is not the owner or has a limited duration on the property. Honorable judges, therefore, Caden did not only have physical control of the land for 12 years, but he also had an intention to possess the land. Proceed, judges, allow me to add that the acquired title by the paper owner of the property, Damon Foote, has been extinguished by way of prescriptive rights. This is relying on Section 5, the title of Land, Act, Chapter 6002, and following the ruling in Ramkishoon versus Funky Fong, referenced on pages 5 and pages 86 of the bundle. In this section, it is stated that immovable property may be held heretofore in full ownership and shall not be subject to any rule of succession or to any other incident attached to land tenure. In the case of Ramkishoon versus Funky Fong, it is stated that indefeasible transport have exceptions in that it has never been absolute and not as strongly preserved as under the Land Registry Act. The acquisition of the land by prescription is not distributed by his provision. Your Honor, in applying these rules to the fact, does it mean that Damon's title as the paper owner is not recognized at the counsels for the appellant may want to state? No. As was set out in Ramkishoon versus Funky Fong, that there are exceptions to indefeasibility transports, and Damon's transport certainly falls under one of these exceptions. Therefore, honorable judges, it can be said that Damon Foote's indefeasible transport has never been absolute and not as strongly preserved as under the Land Registry Act, since it was prescriptive. With this being said, if there are not any further questions, I hereby end my submission.
I'm sorry, could you repeat your last argument at C? When you were speaking about Damon's transport?
In the last argument, C.
Yes.
Okay. That the acquired title by the paper owner of the property, Damon Foote, has been extinguished by way of prescriptive rights. This is relying on Section 5, the Title of Land Act, Chapter 6002, and following the rule in Ramkishoon versus Funky Fong. In this section, it is stated that immovable property may be held heretofore in full ownership and shall not be subject to any rule of succession or to any other incident attached to land tenure. In this case, Ramkishoon versus Funky Fong, it is stated that indefeasible transport have exceptions in that it has never been absolute and not as strongly preserved as under the Land Registry Act. The acquisition of the land by prescription is not distributed by this provision. Your Honors, in applying these rules to the fact, does it mean that Damon's title as the paper owner is not recognized as the counsels for the appellant may want to state? No. As was set out in Ramkishoon versus Funky Fong, there are exceptions to indefeasibility transports, and Damon's transport certainly falls under one of these exceptions. Therefore, honorable judges, it can be said that Damon foot indefeasible transport has never been absolute and not as strongly preserved as under the Land Registry Act, since it was prescriptive. With this being said, I hereby end my submission.
What do you think of the fact that Damon bought the property in 2021? And the period of Mr. Cadenhand's possession was 2009 to 2021. Damon has only had it for 1 year. Have you considered at all the idea that the period of adverse possession was not necessarily during the time that Damon was an owner, and how that might affect Damon's transport, if at all? Because you say his transport is not indefeasible. He's subject to statutory interests. Adverse possession prescription is a statutory interest. So his transport is subject to that, but he's only had it for a year. And Caden's been there for a period when he was not the owner. Does that make any difference at all to your considerations?
Your Honor, in my opinion, Caden has been on the property since he was 11 years old. And the 1 year that Damon Foot had title to the property does not make a difference.
No, I don't overrun them. I don't want us to vote out. You understand? I think one question for work is what it doesn't show well.
Go ahead.
Your Honors, this case before us, before this honorable court, is a very complicated case, as it raises many questions as to whether Caden has a legal right to the property, whether Caden and Debbie are co-owners, whether if he has a legal title to this property, if he can still claim adverse possession, if it is found that he has sole and undisturbed possession of the property. Or what about Debbie's absence to the property? Does this affect her legal right to the property? Does it extinguish her property? May it please the court, I am Evita Rodriguez, and I present my submissions arguing that the trial judge did not err in her decision and aim in answering these questions, while arguing that Damien do have sole and undisturbed possession of this disputed property. Your Honors, I submit that Caden has sole and undisputed distributed. Sorry.
Mr. Rodriguez, just take a minute. I can see that you're very nervous. Just take a minute and start.
Your Honors, I submit that Caden has sole and undisturbed possession, user, or enjoyment of property. Section 3A of the Title to Land Prescription and Limitation Act provides, and I quote, where the court is satisfied that the right of every other person ordered to recover land or any undivided or other interest in land has expired or been barred, and the title to every person to land has been extinguished, the land to land may be required by sole and undisturbed possession, user, or enjoyment of for not less than 12 years. Please see page 4 of the bundle. Your Honors, the CCJ in Lake Guam posited that for a petitioner to claim adverse possession, he must have sole and uninterrupted possession. However, Lake Guam did not live continuously on the property only stayed on the disputed property when he visited from the United States. Please see page 61, paragraph 22. The court concluded that he did not have sole and undisrupted possession. Caden went into possession of disputed property in January of 2009 when his grandparents died. For the years he occupied the property, Debbie never visited, nor showed interest in the property. She visited in December to convey the property, 11 years after she migrated, 11 years after her parents' funeral, to convey the property into her name as the sole intestate heir of the property. During this time, Debbie was absent. Caden remained in possession of the property uninterrupted and undisturbed for 12, counting from when he took possession after his grandparents died and when the property was conveyed to Debbie in January 2021. Additionally, there was no one to occupy the property with Caden during these years. Thus, Caden had sole and undisrupted possession, user, and enjoyment of the property for 12 years, even before the property was sold and conveyed to Damien. Therefore, Caden can claim adverse possession. Your Honors, we, the respondents, acknowledge that Caden have a legal right to property under the law of succession, codified under Section 5 of the Civil Law of Guyana Act, making Caden and Debbie co-owners as they both have equal rights to the property, which would bar Caden from claiming adverse possession, as persons with legal title cannot have adverse possession set out in plural. Please see page 14. However, in Dennis v. Lucy, it was held that a co-owner can prescribe, but that a co-owner can only prescribe against his fellow co-owner if he can prove that there was an honest and deliberate defiance of one co-owner to the other of their co-owner's title for the statutory period. Debbie deliberately conveyed the property in her own name as sole intestate heir to undermine Caden's rights to the property, and she conveyed the property without Caden's knowledge. He was only made aware of the transfer after she sold and conveyed the property when Damien sought action for possession. Additionally, in the Tulsi Prasad case, it stated that once the paper owner does not take steps to stop exclusionary user from, then they can lose their ownership after 12 years have expired. Please see page 122 of the bundle, paragraph 26. Debbie told Caden Debbie told Caden she had no plans to move back to Guyana and not anytime soon at the funeral in 2009. She never asked or told Caden to move out of the property. She left him there to live uninterrupted. Debbie never paid interest in the property as the owner, never paid taxes, never paid the taxes. Caden did that. She never repaired anything on the property. Caden did that. She never took any responsibility as a true owner of the property. That is what Caden did. So why not Caden? Why Caden cannot have that declaration in his name, right? He can have the title. Therefore, Debbie's right was extinguished before she conveyed the property to Damien. Your Honors, Section 5 of the Title to Land Act provides that, and I quote, "No action shall be brought by any person to recover any land after the expiration of 12 years from the date on which the right of action occurred to him, or for the first occurred to the person to whom he claimed to that person." Please see page 7 of the bundle and also page 9, section 13, that says similar, of the same act, sorry. Therefore, Caden's prescriptive rights still stands. Your Honor, the permission and consent of Caden's grandparents expired when they died, and therefore he took possession of the property thereafter. Section 3 of the Title to Land Prescription and Limitation Act provides, and I quote, if possession, use, or enjoyment was not taken or enjoyed by fraud or by some consent or arrangement expressly made or given for that purpose. Caden's grandparents brought Caden to live with them and raise him when his mother died, which created a license, making Caden a licensee. Caden's licensee ended when his grandparents died, after which he took possession. He therefore did not need Debbie's permission to occupy the property. He was already occupying the property when she told him that he can continue living there. Your Honors, Caden lived on the property since he was 11 years old, and he continued to live there for 20 years. This place became Caden's home. That is the only home he knows, and the place where he can call home. To remove him from the property would be depriving him of property, which would violate his fundamental rights protected under Article 142 of the Constitution. Please see page 3 of the bundle. The Constitution is a supreme law, and to act outside its scope would be acting out of vice of the Constitution. Caden should remain in possession, and the trial judge's decision should stand. With this, I end my submissions.
I have a question for you. I noted earlier on in your submissions, you made mention of the fact that when Debbie attempted to pass the property, she did so to undermine Caden's rights that he got as a beneficiary, correct? Right. So when Caden's grandparents died in 2009, is it your submission that he continued in occupation as a beneficiary or in his own right?
In his own rights.
That was a little confusing for me because you began by telling me that statement, which I wrote down word for word. And then you went on to tell me about Caden living there. And so you don't accept that Caden is a beneficiary under the estate.
Originally, he is, but Debbie claimed to be the sole intestate heir, which would mean that there's no other heir but her, which that is not the case, which means she's trying to cut him out of the picture so he wouldn't have any sort of benefits to the property. But regardless of whether she did that, she was still on the property for a number of years continuously. And he provided the responsibilities as a true owner to the property that Debbie never did.
Okay, thank you.
Our counsel for the appellants ready to respond? Do you wish to respond to anything that was raised by the respondents? You'll be doing it, Ms. Boodoo? Go ahead, whenever you're ready.
Your Honors, I rise to respectfully rebut the submission of the respondents. Debbie operated within her legal right to vest the title to herself and hereafter enter into an agreement of sale, a purchase and sale with Damon. He is classified as a purchaser for value. The Honorable Court is guided by case law to interpret this law. And this particular instance, respectfully, Your Honors, this court is obliged to follow the ruling of the cases of Orin Harilal, Chetram, and other cases supporting our submission. The cases that respondents raised do not deal with family matters. Family matters are dealt with differently as it relates to law and adverse possession. The cases they have raised, the facts are different. In the Lee v. Walker case, it showed that there was dispute between family members. In the Bisnot v. Shupasad case, it showed that there were payments made. So all of these taken into consideration, we have to refer back to the cases of Orin Harilal and Chetram Prasad Lakan and other cases that support our submission. Thank you, Your Honors.
Thank you. We're told that there's going to be an opportunity as well for the respondents to reply. Are you going to use that? Ms. Parks?
Your Honors, the appellant's main argument is that Caden had possession of the property. They base their argument saying that permission was given to him by his aunt, Debbie, when she said he can stay on the property as long as he likes. However, Your Honor, I must say it is an honor. It is a pleasure to stand before this court to rebut the claims made by the appellant in this regard. Your Honor, as presented by the junior counsel, that Caden had acquired possession from his grandmother at the age of 11 when he was staying with them under certain circumstances. This permission came to an end when Caden's grandparents died. Thereafter, Caden took possession by continually staying on the property. Your Honor, it is therefore not logical to say that Caden had permission under the Title to Land Act, because it is established that his permission came to an end when his grandparents died. The appellants further argue that the presumption that intention to create legal relations between family or family members works against our argument, because Caden and Debbie had family relations, were in family relations. But I wish to rebut this presumption by saying that as it referenced to the case or the ratio decidendi in the case Romeo versus Romeo cited in the Lake Ram case on Arabondo, this presumption is rebuttable because of the fact that Caden and the title owner, which is Damon, has no relations. And in this case, it states that where there is no relations, there is a higher possibility of rebutting that presumption of intention to create legal relations between family members. On this point, Your Honor, we submit that in addition to the arguments put forward by both the junior counsel and the senior counsel, we submit that the trial judge did not hear in declaring or giving declaration of title to Caden. And therefore, our humble request is that his title be recognized under the Deeds Registry Act so that he becomes the sole owner and proprietor of the property. here ends like my submissions. Thank you.
Thank you. We're going to need 5 minutes to come to decision in this matter and finish with the scoring on the score sheets that have been provided. But before we adjourn for 10 minutes, please, I would like to direct everybody's attention to paragraph 21 of Mathan and Kujal, because you all seem to be arguing that it says that co-owners cannot prescribe. And paragraph 21 acknowledges that they can. So that judgment does not rule that co-owners cannot prescribe. It says in this particular case, the widow was not successful. So just bear that in mind for the rest of your practice. We're going to start with giving our decision and judgment first, and then move on to who has been the most successful team, the most successful advocate, the best research team. I'm going to read my judgment. Our decision is unanimous. But I'm going to read my judgment and we'll see if Justice Haniff has anything that she wishes to add. I start again by asking everybody to make a note of paragraph 21 of Pujal. Please don't come to us in 2 years and argue that. And two of the main issues to be determined in our view was who's entitled to legal ownership of the property and whether Caden was a licensee or not. We wish to acknowledge from the outset that you are all law students and we think you've done a fantastic job with identifying the issues, identifying the law, and presenting arguments for both the appellant and the respondent. A really, really good job, especially taking into consideration that many of you have not done, some of you have not done real property as yet, and Guyanese real property is extremely difficult to learn and understand and keep in context. And you've done a really good job with that. So congratulations to you all and thank you for your able assistance with the cases and your bundles of authority. So the issues as we have identified, much as you have, are whether who's entitled to legal ownership and whether Caden was Debbie's licensee or not. Concerning legal ownership of the property. The rule concerning legal ownership of property in this particular situation is set out in the Intestate Succession Civil Law of Guyana Act, the rules for intestate succession, section 5, 1A and C, which says that when a person dies intestate, their property shall be divided equally among the children, their descendants taking first terpes in case any of the children are dead. The facts in this matter are that John, the grandfather, owned lot 64. He and Kamala, his wife, had 2 children, Olga and Debbie. Olga died in 2002, leaving her son, Caden. John and Kamala died in 2009, and John died intestate. If John had 2 children, Olga and Debbie, on his death intestate, they're entitled to equal shares in lot 64. Olga is dead. Caden is Olga's descendant. The Prosterpes rule says that he gets her share. Lot 64 in law, therefore, ought to be divided equally between Debbie and Caden. Our conclusion is that Debbie and Caden are entitled to equal shares in lot 64. The second thing that arises is whether Caden was Debbie's licensee or whether he was in adverse possession of lot 64. And the rules concerning this are set out in some cases and in Chapter 6002, titled Land Prescription Limitation Act, Section 10. No right of action to recover land shall be deemed to accrue unless the land is in possession of someone in whose favor the period of limitation can run, hereafter called the adverse possessor. Adverse possession refers to your status on the land. It asks, what capacity do you occupy the land in? As a tenant, as a licensee, are you there with consent? Are you there with agreement or not? The court in Victon West Banks Estate, which is a Guyanese case, said that whether possession is adverse depends on the character of the defendant's possession as a matter of right. It is a question of capacity. The facts in this concerning Damon. Damon has transport 4556 that he got in December 30th, 2021. He's now the legal owner of lot 64. He has no relationship with Caden. They're not family, they're strangers. I think this is something that counsel for the respondents were arguing, that Damon and Caden have absolutely no relationship together. Applying that law, there was no statement of any consent, agreement, or tenancy in the facts. On that basis, we find that Caden was in adverse possession for the period December 30th, 2021 to the date of the decision in that matter. That's about a year. Concerning Debbie, Caden is Debbie's nephew. At the funeral, Debbie told Caden he could continue living at the property because she had no plans to move back to Guyana anytime soon. Debbie has never asked or told Caden to move out of the property. She left him there to live uninterrupted. She is visited On every occasion, she stayed at the property and was in a good relationship with Caden. She then became legal owner by transport passed in 2021. So before Damon bought the land, Caden occupied for 12 years. From January 6, 2009 to January 8, 2021. His aunt gave him permission to live there, never revoked that permission, and stayed here with him on 3 occasions. His occupation of lot 64 was therefore not adverse. His capacity was as her nephew licensee. We wish to say, well, I wish to say at this point that I think you did an admirable job, Ms. Jagu, when you related the laws you saw it to the facts that you had been handed in your brief, and Ms. Rodriguez, trying to show that Caden was not there as a licensee because he had been there before, at least not as Debbie's licensee, because he had been there before Debbie even had an interest in the property. Good job, but not enough for your clients to win in this regard. Concerning Caden, Caden is by himself entitled to a half share in lot 64 by operation for rules of intestate succession. I mean, that's how the rule operates. So he has a right to occupy. His right is referable to a lawful title, and possession is never adverse if it can be referred to lawful title. And I set out in the CCJ case coming from Guyana, Tulsi Prasad and Andrew James Investments Limited, which refers itself to 2 extremely old English cases. So you had a right to be there. You can't prescribe against yourself. Your auntie gave you permission. You can't prescribe against her. You can prescribe against Damon, but only 1 year of your occupation was referable to the time he had a title. So for those reasons, Caden has not been in adverse possession, and we must allow the appeal. Before Justice Haniff goes on, our question though would be, what next? Because Caden, as rightly pointed out by Ms. Rodriguez, should not be shoved out of the home that he has an interest in, that he has been in, but not necessarily for her reasons of morality and kindness. But the law says that when your grandfather dies intestate, you are entitled to a portion of this. So the question would be the one that we had posed to Ms. Daniels, what might be Caden's remedy? And we just want to remind you that his failing to prove prescription does not mean that he does not have any rights. And that's something that's very important for you to understand when you go into practice. Don't have tunnel vision. You know, your client, you have to find the avenue to protect your client's rights. And it may not be prescription. It may be through an estate action or some kind of estoppel claim. So I'd like you to also consider what would Caden's rights be and what would they be vis-a-vis Debbie, you know, and your client. You have, but this was not the simplest question. On the face of it, it was very simple, but it was actually quite complicated, and good job all. But the appeal is allowed.
Yes, I'd like to echo the sentiments of Justice Haniff. The teams did very well in preparing for the moot. And I would like to encourage you to continue to persevere in this sort of enterprise. You know that I'm happy to see Moot Court Guyana be reestablished. Back in the day when I was a law student, I mooted in a similar moot like this every year for the first 3 years of because I loved Moot Court as well too. And I mooted in the Hammersmith mooting competition, which they have in the law school as well too, into the finals. So I'm very happy that they're giving you an opportunity to be advocates while you're studying the law. And you've done a very good job in grasping issues and trying to apply them. Unfortunately, sometimes the law is against you. And as Justice Peer explained, not because Caden is shut out in the court for prescription means he does not have a remedy elsewhere. You just have to craft the right remedy for your client based on his peculiar facts. I was very surprised that you found my judgments. But those who practiced before me know that Harry Lal is the only exception to adverse possession by family members. And the rule is very simple. You have to show hostility to show that the permission came to an end. Very simple, right? If you're there with permission it has to show some sort of hostility among the family members to show that you're no longer welcomed there at that home and your time for adverse possession will start to run. I liked Ms. Jagu's argument, which I found was also part of another judgment I'd given in relation to the fact that Kaden did all these repairs in the house. It seems unfair that somebody will do a lot of repairs and maintain a house. But unfortunately, the law says that, as Lakeisha argued, you enjoy the property free. So you're allowed, the law allows you to do those sort of repairs for your own benefit and comfort. You may be able to claim it back from the estate, the improvements to the property, but that alone is not sufficient to ground an adverse possession claim. So in this particular matter, unfortunately, Kaden had a very uphill task, which meant that the respondents in their arguments also had an uphill task to be able to successfully argue for their clients. And we took that into account when we were doing the grading and the understanding, but we want you to understand that overall, it was a very close moot. Okay, it was very, very close, and it came down at the end to one single point when we had to decide. So you have the score sheet. That's it.
Currently, I have a score sheet. Before I read out the score, when I still have your attention, I would like to refer you to one other case as well. It's called B.B. White and Samina Ali. And when you're doing family members, I recommend White and Ali, together with Mathan, of course, Justice Hannes Mata Harilal, and Bisnot and Shupasad. And White and Ali was one of the earliest ones, and it was actually decided by our current, the Honorable Chief Justice's father when he was Chancellor of the Judiciary of Guyana. It's Chancellor George's decision. And I don't think it's referred to in Mathan and Kujal, but it predates Mathan and Kujal. It's very important that you know of it. Did you refer to that in Harilal? Bibi White and Ali? Okay.
All of them are in my judgment. You want to do the score sheet? What am I looking for? The other score sheet. The final one.
Yeah, but where's the
Oh,
lead up to this one?
no, we don't need.
All
the
right.
Preliminary one.
Our first place team, and your first place is based both on your advocacy and your bundle, the documents you have presented. It is not based on which team won, it's based on the work you did and the way you presented your case. The first place team is the team of Jagu, Rodriguez, and Parks with 101 points. 66 for the advocacy and 35 for the materials that they provided for the court's use. The second place team is the team of Todd, Daniels, and Voodoo with 96 points. And they got 67 for their advocacy and 29 for the documents they provided. The best advocate is Miss Ashmina Jagu with 66 points. And she beat Miss Daniels by 1 point. Miss Daniels got 65 points. The best research is the team of Todd, Daniels, and Voodoo, even though their presentation was at least 2 points poorer than the other team. They referred to
A lot of the cases.
a lot of cases that were relevant, even though some of the paragraphs were not brought to light. So that's the best research. The most improved advocate. Justice Hanek was not here on the last occasion. I was, and that's a difficult, a very difficult decision because so many of you presented so well on both occasions. You know, I think the four of you, the four senior and junior counsel, one of the reasons that you won at the last moot was just because your delivery was so good. You are going to be excellent advocates. So how do we find an improvement? So I would say that the most improved advocate today is Ms. Daniels, for the reason that when she was asked to respond, I can't
Question from the
remember what the
bench.
question was, the question from the bench. It was a good response and a clear response that didn't leave anything out. And when I asked if she can extrapolate on what Caden could possibly do, Caden was not even her client, what Caden could possibly do to get some relief for his problems, she on her feet was able to, come up with sensible possibilities as to how he might be able to pursue his case in another court, in another forum, using different laws. So most improved, Ms. Daniels, for that reason. Thank you very much. What happens next? You giving them back these things, or do you want them? Yes. So where do you?
Good morning, everyone. So I am Chantal Paul, the events coordinator for Moot, Guyana, and I stand before you with great pleasure and honor to appreciate, recognize, and reward the participants for their outstanding performance in our first ever land law and immovable property mooting competition. On behalf of Moot, Guyana, I would like to extend our gratitude and congratulate all of the participants for their hard work. Now, I'd like to call an attorney at law, Mr. Samuel Glasgow, to present the participants with the certificates. In no particular order, I'd like to call Cherise Melville, the researcher for Team 3. Now call on Senior Counsel Ashmina Jagu. Junior Counsel Evita Rodriguez. Researcher Yeshuba Parks. This one and this one. Followed by Senior Counsel Tandika Todd, Junior Counsel Nikisha Daniels, Researcher Tiffany Budu. I would now like to call Angel Stevens, the Assistant Treasurer for Moot, Guyana, to present the voucher that was sponsored by Dr. Latifa Henry, which goes to the Most Improved Advocate, Nikisha Daniels. I'll now like to call Justice Hanif to present the team with the best research. Team with the best research goes to Tiffany Boodoo. This plaque was donated by the Bar Association of Guyana. Thank you, Justice Hanif. I would now like to call the Commissioner of Title, Justice Pierre, to present the team with the best advocate. The best advocate goes to Ashmina Jagu. This plaque was also donated by the Bar Association of Guyana. Thank you, Justice Spear. I would now like to call on the President of Guyana Association of Women Lawyers, Ms. Trotman, to present the medals to the first and second place team. You start in second place. I'll now call on Senior Counsel Tandika Todd, Junior Counsel Nikisha Daniels, and Researcher Tiffany Boodoo. I'll now call in Senior Counsel Ashmina Jagu, Junior Counsel Evita Rodriguez, and Researcher Yeshuba Parks. Thank you, Ms. Trotman. Congratulations are in order to the second place team. And this team receives a trophy that was donated by the Bar Association of Guyana, a stationery voucher donated by Metro Office and Stationery Supplies. I'll call on Mr. Devonish to present the second place team with their trophy. Thank you, Mr. Devonish. I'll now call on Angel Stevens to present the stationery voucher that was donated by Metro Office and Stationery Supply. I'll now call on Tandika Todd, Nikisha Daniels, and Tiffany Boodoo. Thank you, Thank you, Ms. Stevens. So congratulations are in order again to the first place team, which comprises of Ashmina, Evita, and Yeshuba. This team will receive a trophy donated by the Bar Association of Guyana, a 10 weeks internship, compliments of Guyana Association of Women Lawyers. Also, this team receives a book voucher, which is redeemable at Austin's bookstore. I'll now call on Mr. Devenish to present the team with their trophy. Please remain, Mr. Devenish, thank you. I'll now present them with the vouchers that was donated by Moot, Guyana, and Ms. Paul. Senior Counsel Ashmina Jagu. Junior Counsel Evita Rodriguez. Researcher Yeshuba Parks. Thank you, Mr. Devenish. I'll now call on the managing attorney, Ms. Shalom Boyce of Guyana Legal Aid Clinic, to present the winning team with the internship. Senior Counsel Ashmina Jagu, Junior Counsel Evita Rodriguez, and Researcher Yeshuba Parks. Congratulations once again, and thank you. Good afternoon, everyone. Honorable judges, respected audience, our most valued invited guests, participants, members of the Moot Court Committee, a pleasant day to you all. It is my privilege to bring the curtains down on this event by extending heartfelt gratitude to every person who played a role in making this competition a successful one. Foremost, to our wise and patient judges, Honorable Justice Madam Nicola Pierre, Honorable Justice Madam Priscilla Chandrahanif, Attorney at Law Ms. Anastasia Stanford, and Ms. Bash. We are humbled and beyond grateful for each of you for taking the time to listen to the submissions made by the participants, to deliberate on them, and to offer guidance to make a very long decision. We are guided by your corrections and forever impacted by what you have imparted in us throughout the entire
competition. To our devoted sponsors, the Bar Association, Guyana Association of Women Lawyers, Dr. Latifa Henry, Ms. Stacy Paul, Moot Court, Metro Office Supplies, we will forever be grateful for all of you for the assistance throughout this, our inaugural land law and real property mooting competition. To Dr. Kim Kite Thomas, Head of Department for the Law Department, Mr. Chevy Devonish, State Counsel and Attorney at Law, for all of their valued advice and support in the planning and execution of this competition. Despite the limited time given, you were all willing and eager to offer your support to ensure our participants were adequately rewarded for their hard work and dedication in displaying excellence in advocacy. To our brave and dedicated participants, we thank you for coming out here and making the most of this opportunity. To the Honorable Chief Justice, we are gracious that you have been able to give us your courtroom so that we can be able to pull off this competition. And to the staff, we thank you for your assistance in facilitating the live stream and assistance in helping us to make this competition a successful one. In closing, to the members of the Moot Court Board, you have proven time and time again how undefeated we are as a board to pull off 2 successful competitions back to back. Thank you, thank you, thank you. Thank you to everyone once more for coming out, and do enjoy the rest of your day.